This is in the interest of Raylan Borland. We're here today for an adversary hearing.
Ma'am, who are you employed by?
The Department of Family and Protective Services.
Okay, and how long have you been employed by the department?
Going on 3 years.
Okay, and what is your training and experience for that position?
So I've been trained to investigate cases of child abuse and neglect.
Okay. Are you familiar with the family of Raylan Borland, Rachel McCollum, and Joseph Borland?
Yes.
How so?
I was assigned to work with their family in July of 2025.
Okay. And did you sign the affidavit in support of removal and file a petition
Yes.
in this case?
Yes.
Okay. Were the allegations in the affidavit true and correct to the best of your knowledge and belief?
Yes.
Okay. And how old is Raylan?
Raylan will be 2 in October.
Okay. And you said you were assigned in July. What were the allegations that prompted the department's involvement?
The allegations were neglectful supervision of Raylan by Rachel and Joseph, which are his parents.
Okay. And did you investigate the allegations? And if so, what did you do to investigate?
These allegations were received to the department on May 24th of 2025. Those allegations were investigated in the DFW area. I received the case as a transfer in July of 2025. So I was pretty much meeting with the family to see what else needed to be done to go with case closure.
Okay. And what did you learn about the child and the parents?
So once I met with the family in July of 2025, I confirmed that they were living in Childress. They had their own housing. Joseph was working. Rachel was staying home with the child. And they reported to be doing well.
Okay. And so you said you were originally assigned to close out the file. Did you learn something, or what was it that caused the change in direction after you were assigned?
Because this case had been going on since May, and there had been a positive screen for marijuana.
Here and speculation.
All right, sustained.
Okay. Did something change while you were working the case that caused you to go from closing the case to filing this petition?
We asked the family to submit a drug screen.
Okay. And what were the results?
Objection, hearsay.
Sustained.
Okay. Was there a current? Do these parents have a criminal history?
Objection, hearsay, Your Honor.
Overruled.
Yes, they do.
Okay. And what is your understanding of the criminal history?
So, Rachel has a possession of a controlled substance charge from 2020. Joseph also has a marijuana charge from 2019.
Did you have an opportunity to talk with the parents about any drug issues that they may have or have had in the past?
Yes, I did.
Okay. And what did they tell you?
They both denied any drug use since the child was born.
Okay. And did you have concerns about whether or not those were accurate statements?
Yes, based off of the history and the marijuana screen from June.
Objection, hearsay.
All right, I'll sustain as to the statement regarding the drug screen.
Okay.
Not as to what parents told her. I just want to be clear.
So, what was the condition of the home like? Well, actually, strike that. Did you have an opportunity to meet with the parents in their home and observe the family home?
Yes, I did.
Okay. Did you have any concerns about the condition of the family home?
No, I did not.
Okay. Did you have an opportunity to observe the child?
Yes, I did.
Do you have any concerns about the condition of the child or the parent's present ability to safely parent Raylan?
No,
Okay. Was it, but nonetheless, you filed the petition for removal.
yes,
Okay. So you must have had some concerns about their ability to parent Raylan.
yes,
Okay. And you believed at the time of the filing that it was contrary for Raylan's welfare to remain in the home. Why was that?
Leading.
Was it contrary to Raylan's welfare to remain in the home, in your opinion?
yes, it was.
And why was that?
There were several reasons why that was a concern to leave him in the home. The parents have meth and marijuana history. Their last, Joseph, parental rights for another child were terminated based off his lack of cooperation, positive drug screens for marijuana, methamphetamines. Rachel had completed a program and apparently has relapsed. The child's young age, being vulnerable, needing an appropriate caregiver to watch over him. So yeah, that's what I just stated.
And what is the basis for the statement you just made about Rachel's apparent relapse?
Drug screen that was received.
Objection, Judge Hearsay.
All right, the statement regarding or implying the result of that screen, that's sustained.
Okay. Based on the results of your investigation and the information that you relied on, did you believe there was an urgent need for protection that required Raylan's immediate removal?
Yes,
Did you attempt to do any kind of parent-child safety placement?
it was discussed, but it was agreed that that was not the best interest at the time.
Okay. Did you attempt to do what, and why was that?
Because of the methamphetamines history in the child's young age. At the time, there was also no admission of this drug use. It was a denial that there was a problem.
Did the parents identify anyone who could be a safety placement?
They did identify one person, well, two persons.
And why were they ruled not viable?
When the first person was staffed, there was history. It was from many years ago, but it was during that staffing that it was found that it was in the child's best interest to not be in the home.
Okay. And then did you attempt to do any kind of safety planning with the parents?
That's what we were trying to do with that first person.
I see. So that was not successful then?
Correct.
Okay. Were you able to make any efforts other than safety planning or an attempted PCSP to eliminate removal?
Like I mentioned, it was staffed, but it was agreed that that was not in the child's best interest.
Okay. Were you able to make any other efforts to allow Raylan to return home prior to today's hearing?
No, I did not make any efforts.
Okay. Where is Raylan currently placed?
He's currently placed with Diana and Corey McCarty in Childress.
Is that a relative or fictive kin placement, or is that foster care?
That is a relative placement, paternal.
Okay. Is it, in your opinion, in Raylan's best interest for the department to be named temporary managing conservatorship at this time? And if so, why is that?
I do believe it is, so that the child can remain in a safe and stable home while the parents work the services they need to address this methamphetamine use that goes back to 2018. If they, take this time to take in these services, make the changes that are needed so that when their child can be returned to them, there's no concerns there.
Judge, I'm going to object to any mention or as speculation as to there being any current use of methamphetamines. There's been no testimony so far as to any of that.
Sustained as to anything but historical use.
Okay. Have you made a temporary visitation schedule with the parents?
I have not.
Okay, is that something you typically would set up, or is that something that St. Francis would arrange once and if a TMC is established?
Let me correct that. I did complete a visitation schedule, but St. Francis is who is carrying out those visits.
Okay, thank you. Did you discuss with the family whether they have any Native American heritage?
I did not.
Okay, so do you have any reason to believe that the Indian Child Welfare Act applies?
I do not have any reason to believe.
Okay, I assume that when you took the transfer, that information may have been processed in the Dallas-Fort Worth case. Would that be an accurate statement?
That was discussed on May 28th of 2025.
And what is your recall of what was discussed?
So Rachel believes there may be Cherokee, but there was nothing as in a roll call or anything established.
Okay, so at this point in time, you don't have any reason to know, is that right?
Correct.
Okay. Thank you. Pass the witness.
All right, Ms. Riley.
Sorry, Judge. Sorry. I have something stuck in my throat that I just cannot get rid of.
Well, would you like for me to skip over and let Ms. Mullinax go while you deal with that?
If you don't mind, Judge, I'll go grab some water and then I'll come back.
All right. Okay, Ms. Mullinax.
Thank you. Thank you, Your Honor. Jessica, you did the affidavit for removal, is that correct?
Yes.
And you said that Joseph's parental rights were terminated when to the other child?
On the, I have noted 2019.
And on your history for Mr. Borland, it doesn't state that there's any methamphetamine use history, correct?
It's not stated on this report.
And with regard to that placement, is that placement with the McCartys, is that the person or people that adopted the other child of Mr. Borland's?
Yes.
And whenever you were discussing a safety plan with the parents, was that a person that was ever mentioned by either the department or Mr. Borland or Ms. McCollum?
That's the second person that I mentioned.
And so you said earlier that it was determined that that wouldn't work. Why would she not have worked as the placement on a safety plan?
At that time, the staffing had been completed and it was requested that the child be removed.
So hold
sorry.
on. So the second person, which was Ms. McCarty, she wasn't really looked into for a safety plan. Would that be correct?
Because the decision, yes, that is correct, because the decision had already been made for the child to be removed.
And were Ms. McCollum and Mr. Borland, were they agreeable for placement to be with Ms. McCarty if a safety plan was entered into?
I would assume so, since they mentioned her.
And so if they were agreeable, why was the decision made that there would not be a safety plan instead of a removal?
A safety plan is only short term. At this time, the department feels that the family needs long-term help. So the safety plan is short term. If they want to, they can work family-based safety services, but that also is voluntarily. So the concern is that the department feels the family needs long-term help. Safety plans are short-term plans. And it had been decided that this child needed to be removed based off of what I've already stated: young age, vulnerability, parents' past history.
And safety plans, even though they're an agreement, they can be extended, correct?
They can be extended.
So it doesn't necessarily mean that you have a 30-day or whatever safety plan and that's it, correct?
You can say that, yes.
I'll pass the witness. Okay, Ms. Riley?
Yeah, I'm good now. Thank you, Judge. All right, so the initial incident that led to the department being involved was in May, correct?
Yes.
And the child remained in the possession of my client and Mr. Borland up until the end of August. Is that right?
That is correct.
Okay, so for 3 months, the department did not feel that there was any reason to remove.
That is correct.
And in fact, when you first met with them, it would be fair to say that you didn't feel that there was a reason to remove, correct?
At that moment, you're right.
Okay. Now, when you first met with the family, did you make a statement to the effect of the fact that they better hope they've been acting right, otherwise they're going to see you in their dreams?
No.
Nothing like that.
Can I say what I may have said?
Well, I'm asking, was it anything like that?
No, nothing about dreams. No, ma'am. No.
Okay, was it something about how they better hope they've been acting right? Was there something like that?
I encouraged them, not to relapse, or the department would become involved again. And I would have to be involved with them again. If they were to relapse and something came out and a report was received. Nothing in how I feel you're trying to say better or threatening. No.
Okay. All right. So then, what date was the staffing?
Which staffing?
The staffing where you said that ultimately you determined that you were going to remove the kids.
That was the day of removal, which was August 25th, 2025.
Okay. So at that point in time, when you entered into that staffing on August 25th, the position was that a safety plan would be appropriate, and would eliminate the need to remove the child, correct?
Safety plan was being discussed.
Right. And so at the start of that meeting, that was your position. Is that fair to say that you thought a safety plan would be appropriate?
Yes.
I'm sorry.
Yes.
I'm sorry. I know your voice. I apologize, but
Fine.
okay. And so then someone else's opinion was different. Is that fair to say?
Yes.
All right. Were you the only person at that meeting that had been out to actually visit the home?
No.
Okay. How many people at that meeting had actually been to visit the home?
That day there was myself and a coworker.
Okay. Was there anyone else that had done the investigation other than you?
Prior to July 24th, there had been 2 investigators on the case.
Okay. Was there anyone at the meeting on 8/25 other than you that had spoken to my client or Mr. Borland?
Yes, I mentioned my coworker.
Okay. And was that person with you when you were talking to them, or did they have separate on their own interactions?
They did have the initial contact with Rachel, and they were there alone without me.
And when would that have been?
August 25th, 2025.
On the same day of the staffing?
Yes, ma'am.
Okay. But prior to the staffing?
Prior to that staffing, no, just myself and the 2 investigators from the DFW area.
Right. So that's what I'm sorry. So prior to the staffing, when the staffing began, had anybody in that room spoken to Mr. Borland or Miss McCullum other than you?
Yes, my coworker.
Okay. Anyone else?
Not that I know of.
Okay. Pass the witness.
All right, Ms. Seal.
Thank you, Your Honor.
Mm.
Ms. Lepe, were Ms. McCollum and Mr. Borland compliant with any drug screen request from you?
Initially, they didn't feel they needed to, but they did end up screening.
And how many times have they screened for you since you received the case?
One time,
And did the results of those tests cause you concern?
yes.
And part of that was the basis for the removal, is that correct?
Yes.
Now, as far as the current placement, do you have any concerns about Raylan's
No.
emotional or, oh, sorry, emotional
No,
or
I have
physical
no
well-being?
concerns.
Okay. And when was the last time you had contact with Raylan?
I placed him on August 25th, and it was sometime last week that I actually unannounced saw him again.
And at that time, you had still no concerns, is that right?
Correct.
Pass the witness, Your Honor.
Okay. Mr. Graff, back to you.
Just a couple of brief follow-ups. Ms. Lepe, counsel on cross was asking you a couple of questions about family-based services and safety plans. Was the family willing to work family-based services?
I didn't discuss family-based that day, on August 25th.
Okay. The only thing they were really willing to do was the one drug test that Ms. Seal just asked you about. Would that be a fair statement?
Object to leading.
Okay, if you don't lead the witness, I'll sustain. You can rephrase your question.
Okay. You just testified in response to Ms. Seal's question that the parents were willing to do a single drug test for you. Is that accurate?
Yes.
Okay. Were they willing to do any other drug test besides that one?
Well, I will say they were receptive when I provided information of where they could go to get something done. So they were receptive of that information. But at that time, they were wishing to proceed with the drug screen in hopes of case closure.
Right. And your prior testimony was that they denied having any current substance issues, correct?
That is correct.
Okay. And with regard to safety plan extensions, are those limited or unlimited?
Well, I would say it's limited on my behalf as an investigator because I would eventually have to move the case on to case closure or family based, and I would not be who continues to extend it.
Okay.
So, not unlimited for myself.
Okay. Are they? So as far as your involvement with a safety plan, would it be limited in time?
Yes.
Okay. All right. Thank you. Pass the witness.
Ms. Taylor, the drug screen, and I'm not talking about what the results of that, but the one that they agreed to go do, was that a UA or was that hair? What was it?
This was a UA.
Okay. All right. Thank you. I just wanted that clarified. All right. Ms. Riley, you have any further questions?
No, Judge.
Okay. Ms. Molinax?
Thank you. Jessica, you said that they agreed to screen one time. Did you ask them to screen more than one time?
No, I did not.
And you said that a safety plan is not unlimited for you. Is that because you're not always involved in the case?
It's because I eventually have to close the case.
Or transfer it to family based, as you said a moment ago, right?
Well, I would close my investigation, and then a case opens for family based.
And so you could transfer it to family based or something else for them to take over the case. And so that's how you become uninvolved, correct?
That is correct.
And you said earlier that you'd been employed by the department for 3 years, but you worked for the department before that too, right?
Yes.
And how long did you work for the department that time?
19 years.
So in your, let's say, 22 years of experience with the department, are you familiar with how family-based safety services works with safety plans?
Yes. For
Are,
the most part, yes.
are safety plans available in a family-based case?
Yes, they are.
And pass the witness.
Okay. Ms. Seal, any further questions?
No, Your Honor.
All right, Mr. Graff, anything further of this witness?
Just one follow-up, please, Your Honor. Ms. Leppi, based on the concerns you had from the drug test results, was family-based services appropriate at that point, or was filing the present petition appropriate?
I do not believe it was appropriate.
All right, thank you.
I do want to apologize for my camera. It shows that I'm sharing video, but nothing shows. Thank you.
Okay, I understand. Sometimes we just all have technical problems. All right, Mr. Graff, any further witnesses today?
I do, Your Honor. Briefly, I would call Abigail Lawrence.
All right, Ms. Lawrence, if you will unmute and raise your right hand. You solemnly swear or affirm the testimony you will give today will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, you may proceed.
Thank you, Your Honor. Ms. Lawrence, who are you employed by?
At St. Francis Ministries.
Okay, what is your job title and role with St. Francis?
I am a permanency specialist.
Okay, and how long have you been with St. Francis?
I took a little bit of a hiatus for the last few months, but before that, 2 years.
Okay, and what is your training and experience for your role as a permanency specialist?
We go through a series of core and specialty training for this job. I believe it lasts a little over 6 weeks for that.
Are you familiar with the Borland family?
Yes, I am.
How so?
I am assigned as their permanency specialist.
Okay, so you were assigned, and when were you assigned?
I was officially given access to everything last week.
Okay, did you have, what did you do to come up to speed and prepare yourself for your assignment?
I've read through the removal affidavit and investigation, and I've spoken with Rachel and placement for Raylan.
Okay, did you have an opportunity to discuss? Let me strike that. Did you speak with the father or just the mother?
I just talked to Rachel on the phone. Mm-hmm.
Okay, so you didn't speak with Mr. Borland?
Correct. Rachel told me they're currently sharing a phone, and so she's just kind of been my go-to person at this point.
Okay. Did you have an opportunity to discuss with Rachel the concerns about substance abuse?
Yes, I did.
Okay. Did she make any admissions about recent substance use?
Yes, she did. I called her on September 2nd, and I introduced myself, kind of discussed my role, and we discussed visitation going forward. St. Francis was asking that we do virtual visitation with Raylan and his parents just until we get a clean UA, just due to the positive methamphetamine screen listed on the investigation. So we were a little concerned just about how easily transferred that is. And Rachel understood. She had told me that her and Joseph had gone to a friend's house. They left Raylan with a sober caregiver, and that's when they had used the drug, and she felt terrible, and they had made up their mind they weren't going to do that again. And it was, from what she explained, kind of a one-time occurrence.
And did she say when that was?
No, she did not give an exact date, no.
Okay, but it was, she gave it as an explanation for the test result. Is that right?
Correct.
All right, thank you. Pass the witness.
Okay, Ms. Riley.
When you had that discussion with my client, did you specifically ask her to explain results?
No, I did not. She kind of just was forthcoming with that information, and I appreciated her honesty with that.
Okay, but I guess I'm just saying, if that wasn't in direct response and you don't know the exact date, then you're not really sure as to when this alleged event happened. Is that fair to say?
I believe so. She didn't give me an exact date on when they went over to this friend's house. So
Well, so you don't know whether it was 6 months ago or 3 months ago? No idea, correct?
correct.
Pass the witness.
Ms. Mullinax?
No questions.
Okay, Ms. Seal.
No questions, Your Honor.
All right, Mr. Graff?
Are you aware of, prior to this admission, whether the parents made any statements giving a different reason for the drug test results?
No, I'm not aware.
All right, thank you. Pass the witness.
Ms. Lawrence, I want to make sure I understood your testimony right. So correct me if I either misheard or interpreted this incorrectly. Was mom's response to you in response or reaction to your discussing the drug screen?
No, it was in response to the conversation of holding their visitation with Raylan virtually for the time being until a clean UA was given by them.
Okay, all right. So you hadn't confronted her with the drug screen or said, here's the results or anything of that nature?
That's correct. No, I did not.
Did you at any point in time do that?
No.
Okay. All right. Thank you. Okay, anybody else have any further questions for Ms. Lawrence?
No, Your Honor.
No, Judge.
All right, Mr. Graff, then any further witnesses?
No, Your Honor. Say rest.
Okay, Ms. Riley, any witnesses today?
Judge, could I have and I hate to do this, but can I have a second to talk to my client?
Sure.
And if
We
Ms.
are-
Mullinax wants to, I know since our clients are together, if she wants to join us, I don't have an objection.
Yeah, I would assume that's probably what you would want to do. Okay, okay, parents, you're gonna get a prompt to go to room 2. You can say join. Okay, let's see, Mr. Graff, did I get all your people pulled back in? I think so. I think I got Casa all back in.
Mr. Armendariz was in a conference, but he confirmed our position, so we can proceed in his absence.
Okay. All right, let me just make sure we've got Ms. Riley. Yeah, okay, we've got Ms. Riley back and okay, I think we're good to go then. Okay. Mr. Graff, you comfortable at least announcing for the department, and then we'll check where we are with Ms. Riley and Ms. Mullinax?
Yes, Your Honor. Just for the benefit of the parties, we discussed the possibility of based on the evidence and the testimony, in lieu of proceeding with a temporary managing conservatorship, perhaps shifting gears and converting this case into an OTP FBSS case. My client is agreeable to that. I know if I understood the court's position, as I communicated to my client, if the parents would submit another UA and that UA was clean, then the child could be placed back, or it sounded like there might have been a discussion of them possibly moving in with a relative. I'll defer to counsel for the parents, but basically whatever that looks like, we would be okay with that. And then just in terms of the mechanics of the paperwork and everything else, I guess I'll defer further comment until we hear from the parents' attorneys.
Okay, I appreciate it. All right, Ms. Riley, your position?
My client is my client is in agreement to do a family-based services case. She'd be willing to cooperate and understands that with the safety plan that right now the child would remain where he's at, but then with a positive, or never mind, with a negative UA, that the child could be returned to her. Even with being returned, she's still willing to work services to complete them, to make sure that there isn't any further issues, and that, you know, he can remain in her and Joseph's care.
So is it, let me understand, they're agreeable like to converting it to like an OTP? Or
If
just
we need to do that, yes. I don't think they have an objection to an OTP if they need to, or we're willing to voluntarily do family-based services.
Okay. All right,
I mean, I
Ms.
think we
Mullen?
prefer to just do voluntary family-based services.
All right, Ms. Mullenax?
Your Honor, I would have the same announcement, and they, if I may, Tracy, they both understand that even if it's voluntary, they have to do the services, or they could have other consequences. And as far as Mr. Groff said something about moving in with the relative, I think they would do that. I think there was discussion of that too. I don't know if that needs to happen or not, but they're agreeable to whichever.
We don't have a position where we're good either way. I just know that that came up during the conversation, so.
And we had that come up too. My understanding was that was maybe discussed with the placement previously. I don't know if the department discussed it, but I think our clients discussed it.
Okay. Well, Your Honor, as far as the department is concerned, we'll defer to the court whether the court would prefer an OTP. Obviously, that has a little bit more formality about it, but we'll defer to the court on whether it's just purely FBSS or OTP. As far as a practical matter, I know, Your Honor, we were in a case in Potter County recently where we kind of did something similar. We recessed for a week so the parent could do some, or the department in that case could do some follow through. I'm wondering here if the parents are willing to do a UA this week, if we defer the final decision on the form of this, just because of the paperwork involved. If we have to switch gears, we don't mind converting to an OTP or FBSS, but God forbid there was a positive drug test, we don't want to have to then ratchet up the paperwork again. So if the parties were in agreement and we recessed on the final order while they did a UA with this week, I just pose that as a request because I think it'll just make everybody's lives easier in the long run.
I agree with that, because in the interim, then Ms. Mullenax and Ms. Riley are still their counsel. So they still have the benefit of legal counsel, you know. So what I can do is just not issue a ruling today, but with the understanding that parents are agreeable to work the services. Let me just explain, Mr. McCollum and Ms. McCollum and Mr. Borland. If I just send you straight to FBSS, you're going to lose your attorneys, because there aren't further court hearings. You know, it's not a legal type proceeding at that point. But I will just tell you, if that's the route that we go, you know, they're still going to be asking you to drug screen and everything. And if something comes back and they got a concern, you know, it'll be straight back here to, you know, a legal removal type case. So, number one, do you think your drug screens are going to be negative?
Yes.
Okay. So what I would like to do is go ahead and just, I'll issue an order in this case for parents to go drug test this week. That'll be, let's see, the prior one was just a UA. So I'd really like to have the hair and UA done. But if the UA is negative, then we proceed with sort of our plan here. And I will go ahead and just at that point dismiss this case and expect parents will go into FBSS. So there would not be, you won't have lawyers anymore, you won't have hearings. But just, you know, understand I'm just lurking out here.
Yes, ma'am.
And they know where to find you.
Yes.
Yes, ma'am.
Okay.
And Your Honor, one other thing that we had discussed with our clients, if And I don't have any reason to believe that either of them would be positive, but if one is positive and the other is negative, we would ask that they be allowed to, the one leave and go somewhere else so that the one that's negative could care for the child.
We would be agreeable to that.
Yeah, absolutely. So hopefully that won't be the case. So whether you all move in with a relative or whether the relative is willing to just continue to be placement, I'm fine with either of those, but until we've got negative tests. So we probably will know that before we ever dismiss this case. So, okay, so what I'm going to do is I will hold any other ruling other than ordering you to go drug test for us, hair and UA, as soon as that can be affected. I don't know whether we got time to do it today. Ms. Lawrence, well, I don't know whether you'd be the one to be doing that or because technically I'm not naming you TMC just yet. Ms. Lepe, can we?
Yes, I've reached out to the Wellington site and have asked if they can take them in today.
Okay. All right. So plan to go do that this afternoon. And then I'll just reserve any further ruling until I hear back from the attorneys.
Great.
Do you guys have the ability to get to Wellington?
Yes, but I have work today. I had originally Abby wanted to do a drug test and I agreed. I asked her if we could do it Friday because of my job. And I had already requested off this week, this morning for the court hearing. And we're very short-handed at my job, so I'm the only available CSR.
Could you do it by noon tomorrow?
I can talk to my boss and so that I would be able to give them a heads up.
All right, let's just say, Ms. Lepe, that everybody's got till noon tomorrow to try to get it scheduled. If Dad can go today and he wants to get it done, great. And then Mom could get there by noon tomorrow.
I will say that the Wellington office will be out beginning tomorrow for the rest of the week. So they can do 1 o'clock today. If not, it'll be next week if they go to Wellington. There's no other, I think the other site is Pampa and Amarillo.
All right, so Ms. McCollum, can you go at 1 today?
Yeah, we
Okay.
would still have to find a ride and I don't know that I would be able to just because I did already request off this morning for court and they do need me, but I can try. That's I'm gonna try. Just like we said, we would have to find transportation as well. And our transportation is his brother, and his brother, I believe, has work today too.
And Your Honor, they're going to be supervised until they have a negative screen anyway. So even if they went next week, they don't get the child back until that happens.
Yeah.
I believe the department can assist with transportation.
Okay, so here's what I'm gonna do. I'm gonna kick it. I'm gonna let y'all figure out when. I mean, Ms. Mullinex is correct. I mean, they're gonna be supervised with the child, so, just the sooner you all can get there, obviously, the sooner maybe the child gets to come back to you all and you don't have to be supervised. But since we will have that in place, then Ms. Lepe, I'm gonna let you just try to figure out when it'll work with them and the testing facility and transportation and all of that. But obviously, I think everybody wants it done sooner rather than later.
Yes, ma'am.
So,
And
okay.
Ms. Lepe can help you with transportation, so
Okay.
don't be shy about reaching out to her.
Yes, sir.
Okay. Thank you.
Thank you.
Okay, then, I'll just wait to hear from everybody.
Okay.
So until then, you're still under the court's temporary order, this order for protection. So just know that that's still out there. Okay, I appreciate
Thanks,
y'all very much, and I wish parents the best going forward. I hope this all works out, but take it seriously
Yes, ma'am.
because I do. Okay,
I do.
all right. Okay, thank y'all.
Thank you,
Thank
Your
you.
Honor.
Thank you.
All right, then at this time, I'll call Potter County cause numbers 86168D in the interest of Aaliyah Montez, cause number 93907E in the interest of Daniela and Dominic Montez. We're here today in both cases on status hearings. We are conducting these through Zoom under a finding of good cause and agreement with the parties. We are live streaming. Ms. Goodman is making our record. All right, then we'll go ahead and take announcements.
Daniel Trial for the Texas Department of Family and Protective Services. Crystal Potts is my permanency specialist. We're present, ready, Your Honor.
Savannah Kincaid, I
Dee Dee
represent Ms. Rogers. I'm present and ready. Sorry.
T.D. Hammonds representing Adriana Ortega, mother of Aaliyah Montez, cause number 86168D. We're ready, Judge.
Stacy Zabala on behalf of the children.
All right, thank you. Okay, let's see, Ms. Potts, are you going to give us the update?
Yes, Judge.
Okay, fire away.
Okay, so Adriana is doing very well. She has been completing all of her services. She does have services from her prior case with Johnny, and those services kind of merged into what we were doing. So she lacks specifically an individual therapy to address her past traumas and building the relationship with Aaliyah and her coming home as a teen. She did complete her hair and UA screens for us, and I did have those as observed collections on 9/3, and she was negative on all three. As for Chelsea, she has completed 4 of her parenting classes. She'll complete RBT on the 17th. She is seeing her therapist every 2 weeks, and she's also attending AA twice a week. She screened for hair and both UAs on the 2nd, and her hair is still pending. UAs are negative. Aaliyah was apparently never taken for her hair follicle screen. I just pulled that up again, and it shows that hers expired. The twins were taken, and theirs were both negative. Aaliyah is currently in 10th grade. She has multiple different things that she qualifies for on special education and her art. She's got a specific learning disability, speech impairment, other health impairment, ADHD, dyslexia. I did contact the school and did not hear back from them on her today. I did hear from placement, and she has had just one outburst where she kind of lost her cool for a minute and was just begging to come home with mom. She says she's tired of being there and just wants to come home. As for the twins they're very outgoing. They're a great time. They love everyone, and the only one that seems to be having a little bit of issues at school is Dominic. He appears to continue to have issues with boundaries for keeping his hands to himself and understanding that you can't just hit people even if they hit you, understanding to talk to an adult instead of addressing it yourself. Other than that, the school reports that they're doing great, and so does placement.
Okay, and Mr. Montez is still incarcerated, is that correct?
Yes, ma'am.
In Your Honor, family plans of service were generated. All parents have signed. Those have all been filed.
Okay, great. Very good. Okay, Mr. Hammonds, anything today?
Judge, we're just really asking if there's any way to speed up the placement of Aaliyah with mom. Mom has completed everything in regards to Johnny's case. she's willing to continue cooperating with the department. That case with Johnny is working toward monitored return and then reunification. With Aaliyah being 15, I guess it's just our position. If she wants to go home with mom, mom's in a good place. Let's just do it. And mom's willing to enter into counseling with Aaliyah, family counseling, individual counseling. I guess our position is their reason for not wanting to put her with mom is not sufficient.
Okay, well, I want to hear from everybody, so I understand the request and so
Yes,
we'll
Your
come
Honor,
back to that.
well, as far as the home study, and we did get notice end of last week that home study was denied. I know it's with Johnny's case, it's been approved. I believe they are working toward reunification there. The main issue on the current home study on this new case, it's kind of one of those things that has to do with the roommate, the history and CPS history and criminal history on the roommate. I think my understanding, Ms. Ortega and the roommate are both doing well. I know that Ms. Zavala may have a recommendation. I know just through the emails that she may have that recommendation to look at mom on this. So it's been more of a policy issue as far as with the department and whether they can approve that home study due to the history on that. Is what came up with Ms. Ortega's case.
But correct me, I just want to make sure about remembering about Johnny's case, but the roommate, they're both on probation, in
Correct.
compliance with probation. Probation has allowed this exception, which
Correct.
normally would not be. And so nothing has changed in that regard.
No, ma'am. I think, and Ms. Potts may correct me if I'm wrong, I think when they went back and looked at during this home study, there were a couple of things in the roommate's past that popped up that they had not seen prior. And so that kind of came up and caused this, but that's kind of where we are. It's nothing, it's more of a policy issue at this time, just due to the history and the criminal history and the CPS history that was noted in that home study.
Yeah, okay. Okay, all right, let me just, before I jump down to Ms. Zavala then, Ms. Kincaid, anything with respect to Ms. Rogers today?
Ms. Potts, is there a home study still pending on Ms. Rogers, or has that been completed?
Hers has been completed and it was approved.
Okay, and is she in compliance with services?
Yes, ma'am, she is. She's working everything just like she's supposed to be. She's made every visit like she's supposed to. She's done very well. Both moms are doing great.
Okay, what barriers are there to currently or here pretty soon placing the children with Ms. Rogers?
There are no barriers at this time. Chelsea she's compliant. She has everything. Everything's going great for her. There are no issues.
Okay, so if she were agreeable to it, if the kids could be placed with her and she would work with the department for as long as it would make you guys feel comfortable, what is the timeline for placing the kiddos with her?
I do not have the answer for that. Maybe Mr. Trout can answer.
Well, and I would say, I don't know, have y'all staffed a reunification or a placement with mom at this time, Ms. Potts? Or because I don't see that the home study's been filed yet, and I have not seen a copy of it. Have y'all staffed that as far as when your timeline on that is?
I need to make a correction. Stacy just messaged me and we are pending approval of the home study based on Chelsea's hair test coming back. That is still pending.
That's what I wondered. Okay.
I apologize.
And Judge, I was just informed a while ago, there is a the hair follicle, Ms. Rogers, has not come back. It was taken around or right before Ms. Ortega's. I think Ms. Ortega's is back. Ms. Rogers' hair follicle has not come back yet on this last test.
Okay. That's kind of what I was thinking, since you all had said earlier that it was pending. Okay. Assuming that that comes back negative, any barriers that you see, Ms. Potts, to moving the kids right away after that?
No, Judge, they're not.
Okay. Okay.
That's all I have today, Your Honor.
Okay. Thank you, Ms. Kincaid. All right, Ms. Vala.
Your Honor, I've visited with all the kids, and they do want to be home with the moms. From the correspondence back and forth about Aaliyah, it sounds like everybody believes that Adriana is doing very well, that her roommate is as well. It sounds like there was some thought about not overwhelming her, which I understand and appreciate. However, we do have this reunification scheduled for Johnny, and it's my understanding, as long as it stays on track, that he should be back in the home September 28th. And at this point, I don't really see any reason to put Aaliyah on a different schedule. They're having visits together, and Aaliyah desperately wants to be back at her old school where she's comfortable and has some very supportive relationships. I really appreciate how hard Miss Ortega and her roommate have worked. I hope this doesn't put extra pressure on them, but at this point, I feel like we should be moving Aaliyah as well. As to Miss Rogers, I feel the same way about the twins. Of course, pending the hair follicle. I do think that's vital information that we need to have. So at this point, it would be my recommendation to return the children to mothers as long as drug screens are good.
Okay. All right, Ms. Rogers, Ms. Ortega, thank you for making my job a lot easier today. So, here's what we're going to do. And if Ms. Rogers' hair returns negative, then we'll place the twins with her.
Yay.
At that point in time. So yay. And same, I don't see any reason not to go ahead and place Aaliyah back with mom. These are placements, as placements.
Right.
Just so everybody's clear. If y'all have any question about what that really means, your lawyers can clarify that. But basically, kids are going home. I will expect you to continue to work your services, and lean on us during this transition, and especially Ms. Ortega with Johnny coming home too. I just, we are here to help.
Yes, ma'am.
We don't want the bad guys. We really want to make sure you guys are on real solid footing before we get out of your life. So, although the law has changed regarding, whether or not your rights can be terminated for failing to work your services, it still means they're important. And so I want you to complete those service plans. And then if we need family counseling with Aaliyah, then, that's great. Let's do it.
Yes, ma'am.
I don't see any harm ever in doing that. Especially with a 15-year-old. I mean,
Yeah.
the easiest of 15-year-olds, sometimes I think parents would benefit from that. So, anyway, we'll place them under those, each of the moms and those situations and conditions. And I would find that the mothers are certainly in compliance at this point with their service plans. I mean, I know this is just the status hearing, but it's great. We love it when we can do this. So, Mr. Montez, I will continue to expect to do what he could do. Has anything been sent to him, Ms. Potts?
He has been, he was able to work some parenting through their iPads there, but there's some kind of an issue with him being able to send me certificates. He said that he can only send 2 and then he has to pay for it or something. So he was supposed to be talking to his attorney to see if they can figure out what's going on with that. He also told me that there are some domestic violence courses on there that he can get into, and I suggested that he go ahead and get into those. So he is trying to do what he can with what is available at this time.
Okay. All right. Okay, then.
And Judge, real quick on placing Aaliyah with Ms. Ortega. I know Ms. Zavala mentioned same track as Johnny, but are we on the same track? You want to go ahead and place Aaliyah and then September 28th get Johnny in, so Aaliyah's there for a couple of weeks prior.
I'm good with going ahead and placing her.
Okay, all right. I just want to make sure on the timeline.
So she can come home and but we can make that little transition and then we'll make the next hurdle. So
Okay.
okay. All right, then, in addition to what I've already found, I would find there'd be a continuing danger to return any of the children home to Mr. Montez, and in fact, impossible. And so, again, let me stress, I'm ordering the service plans as an order of the court today.
Okay.
And so, you know, I know y'all are really close to wrapping up some of those things, but we're still going to be looking at you to maintain housing, you know, maintain employment, maintain transportation for their kids, maintain contact with us. So, you know, all of those, even though once you've knocked out parenting and counseling and all those other scheduled kind of things, we're still looking for that stability.
Okay. Yes, ma'am.
So that's kind of still all part of the deal. Okay. Then I'll see y'all back for the initial perm hearings, and that's January 6th. Now, that being said, if things are going really, really well, I mean, we may be out of it before then.
Okay.
But just so that you know, our next check-in will be January 6th. So I wish you continued really good luck and thank you for working hard and just keep it up.
Thank you.
Thank
you, Your Honor.
And
Okay.
Judge, on that, as far as being out by that date, these are both modifications in which Mr. Montez is the primary on these.
Right.
So it may be that we have to do a mediation or some sort of settlement before then if we can get something worked out.
Sure.
Before
He and you know, I feel like at least he was initially, you know, of the mindset that he was happy for the children to be with moms. So
Yes, ma'am.
yeah. So anyway, you all let me know, and if you need me to appoint a mediator, just let me know.
Yes, ma'am, will do. And I look back, I did not get a signature from Mr. Morales on these, but I'll be reaching out to him as far as that situation as we get further in the case.
He was in earlier and he looked like he was somewhere in the courthouse. So he may be
Yes, ma'am.
stuck in something somewhere. So, okay. All right. Appreciate y'all, everybody. You all are free to go.
Thank you.
Thank you, Judge.
Thank you, Judge.
Thank you all.
Good job.
Thank you.
In the interest of Amari Maldonado, we're here for a status hearing.
We're coming along well. Amari is adjusting well where she's placed. She is sad. She wants to be placed with family. She does go to counseling bi-weekly and they're going well. There was a home study for paternal aunt submitted, but it was denied on September 4th due to a DWI arrest on 8/15. I have submitted a home study for paternal grandmother. We're waiting for that to come back.
Hang on, I lost mom. Let's give her a second to see if she gets logged
Okay.
in. Yeah. Okay, Ms. Elliott, if I'm not sure where we lost her, so if you just kind of back up.
Okay, let me start over, ma'am.
Yeah, that'd be fine.
Okay. Amari's adjusting well. She is sad. She wants to be with family. She goes to counseling bi-weekly and they're going well. A home study was submitted for paternal aunt and it was denied on September 4th due to a DWI arrest on August 15th. We have submitted a home study request for paternal grandmother. I'm currently waiting on that to come back. Dolores is doing really well. She's completed rational behavior therapy and her psychosocial. Her OSAR is scheduled for tomorrow, and she's currently doing her parenting and counseling. She's been compliant in providing check stubs. She's maintained contact. Visits with her and Amari are going really well. Some are virtual, some are in person. We are still currently trying to set up visits with Amari and her brother Santos. We have been unable to do that due to availability by Santos's father, but everything else is going really well.
Okay, great. All right, Ms. Stevens?
No question, Your Honor.
Okay, anything to add today or any requests on mother's behalf?
No, she just wants to work her services as fast as possible. And I think that they've already started her on several of them. But other than that, as far as we're concerned, everything seems to be going well and communication with the department's going well.
Okay, excellent. Mrs. Garcia, do you have any questions about anything? You'll have to unmute for me. I'll send you a prompt, see if that pops up.
Okay, sorry about that. I was just wondering to see when I would be able, once I finish all my services and stuff, if I would be able to get a Marty back.
Yeah, that's the plan. I mean, get through your services and as long as you're demonstrating stability and everything, then we start working her back home.
Okay, because I'll be done with all my services by Monday, next Monday.
Okay. Okay. And I don't know, Ms. Elliott, is that what you understand?
I haven't followed up with parenting or her counseling, but I plan on doing that this week to see how that's going and see how many sessions she has left.
Okay.
And Judge, I guess some of that would determine, I guess, if recommendations come out of the OSAR and that type of thing.
Yes.
But everything else seems to be going very well. We're just waiting on recommendations from those couple of services.
Yeah, so Ms. Garcia, there's some things that you did that then those providers send back to us some written recommendations, and some of those may have, you know, a suggestion or a recommendation that you do something else. Okay, so I understand that as far as you know, you may be done Monday, but we may not know that just yet. Okay, but I'm gonna tell Ms. Elliott that, you know, if things are, she knows if you're pretty much done and we don't have any further recommendations, and it may even be we have recommendations, but those could still be done if the child is reunified with you. So, you know, let us have an opportunity to get all the information. And then what they do is they'll sit down and have a meeting and look at, okay, when can this happen and how is that gonna happen and transition? Okay.
Okay.
I don't want it to take any longer than it has to take.
Yes, that's what I've been trying to maintain all these services and trying to get it done. And I'm visiting with my daughter and she's just ready to come home and I'm ready to have her. Oh, and I was going to ask too, once I get her, would I get my son back as well?
Okay. I don't have any of that information here with me. Is he placed with?
He's with his father.
Yeah, with another parent.
Yes.
We didn't remove on that, Your Honor, that we don't have a case on him.
Yeah, that's not part of this case.
Yeah, that's not part of this case.
Yeah, but that was my recollection, was that he was just placed with a non-offending, I mean, he just went to a non-offending parent, so to speak.
Yes, ma'am.
Yeah. Okay. So the deal is there, Ms. Garcia, is I don't have any jurisdiction over him. I don't know whether you and the father had any prior court orders about him or any other agreements.
I have the main custody of him, and once all this is done, he's willing to give him back to me.
Then I'm guessing the answer probably will be yes. Okay. But understand again, I don't have any control over that.
Okay.
Okay. All right. Okay, Ms. Zavala?
I want to clarify, the home study that was denied, was that on Aunt Jennifer?
Yes.
Okay, because I know Amari knew that was in progress. Has the home study on grandmother already started?
Yes, it has.
Okay, is there any need for an expedited order on that, or is it going to be treated as expedited?
I'm not for sure on that. I'll plan on following up with them today.
Okay, I think just to be safe, I would like to ask for an order for expedited home study. I know that each of these cases is separate and has separate facts, but she's potentially about to be left in the placement while all the other kids go back home. So I want to make sure we've got, we're moving as fast as possible on any home studies, to make sure she's not left there by herself, you know. So it is a safe and appropriate placement. She is doing well there. She's doing well in school. I've gotten to visit with her in person before. This time it was by video. So I don't have any safety concerns about this placement, her or anything like that. But I do think it would be helpful to get her with family as soon as possible.
Okay, so that's on, did you say maternal or paternal?
Paternal.
Paternal, okay.
And Ms. Elliott, you stated that was submitted on the 15th of August. Did I hear that right?
It was, I'd have to look up the date. Let me see if I can pull it up real quick. Give me 1 second.
Sorry, I thought a while ago you stated on 8/15 it was.
That was when Jennifer Maldonado was arrested for a DWI on the 15th.
Okay.
I can pull it up real quick.
While you're doing that, quick question, have service plans been developed, signed and filed?
Signed and filed on the 8th of August, Your Honor.
Okay.
It was submitted on 9/5, September 5th.
Okay, so about a week, 4 or 5 days ago. Okay.
Is it too late for me to order it expedited?
I can try to call them and see if we can get it expedited.
Okay.
I've never had one ordered that after it was already submitted, Your Honor. So
Me either.
Yeah, I think it's too late.
Yeah, I think since it's already in there.
Yeah.
But the other ones seem to come back fairly quick.
Mm-hmm.
So hopefully this one will too.
All right. Okay, then, today, then I'm going to order the service plans as an order of the court. Ms. Garcia is definitely in compliance. You know, we'll try to get these recommendations in as quickly as we can and take a look. If everything's looking good, then I have no problem with St. Francis starting to look at a reunification plan.
Awesome. Thank you, Jesus.
And you know, we'll move forward with the home study just in the event there's some recommendations that might take you a little while, Ms. Garcia. In the interim, we could get her with family. So that's kind of plan A and plan B, okay?
Okay, and like with the plan A, is it like in a time frame? Because if the other kids are leaving, I don't want her there too long by herself either.
Yeah, I mean, I can't tell you a time frame because I don't know when we'll get those recommendations and what might be recommended. I just can't tell you. I'm sorry, but I just have no way of being able to do that.
Okay.
But if you're doing well, I will say this again. We don't want her in care any longer than she has to be. You know, we want to get her home so we can monitor, make sure everything's going well, and then we want to get out of your life.
Okay, yes, I just want my child home.
I understand. Okay, then I'll see everybody back for our initial permanency hearing. That'll be January 6th of 2026 on a 9 o'clock docket. Again, Ms. Garcia, I mean, she may be home long before that, but that's going to be kind of a check-in date unless everybody feels like we're ready to get out of it before that.
Okay. And with Heidi, like to talk to her, Heidi, about all that.
Okay, yeah, you can visit, you can continue to visit with her and your attorney and just as usual.
Okay.
Okay. All right, I appreciate y'all. Thank you for your patience. Sorry we're running behind, but I'll see you back in January unless we're done.
Okay.
Thank you.
Thank you, Judge.
Thank you. At this time, then I will call Potter County cause number 95058E in the interest of Tremaya Campbell Johnson. We're here today on a motion filed by the mother, Kristen Campbell, by Mr. Nowak. We are conducting this through Zoom. I will, for the record, state that Ms. Campbell was logged into my waiting room earlier. The court's docket is somewhat behind today. My apologies to everybody. We had an adversary hearing that went longer than anticipated, but she was logged in earlier, but she is not out there right now. So I just want that clear on the record that we did have her, and perhaps that, you know, the delay, the court's delay today, maybe she had to be somewhere. I don't know. Mr. Novak, due to that, I am going to toss this to you. Would you prefer to try to reschedule this hearing? Where we'll try to set it like first on the docket so we know that we will be on time, and you know, so your client will have the opportunity to be here.
No, Judge, I think this is purely argument today, and given that trial is just around the corner, I don't want to delay any further, and I sure don't want to burden a future docket on something that we can probably handle in about 5 minutes today.
Okay, I just wanted to throw it out because we are running, you know, we are running behind, and I just don't want to. I wanted to give you that option. So
when I send the link, it obviously includes the docket, and I you know, folks can follow along like I do on YouTube to see when you're running late or not. But no, I'm prepared to go forward, Judge.
okay, very good. All right then, we'll go ahead and take announcements then.
Daniel Trout for the department. We're present, ready, Your Honor.
Vince Nowak on behalf of Kristen Campbell, present, ready.
Stacy Zavala on behalf of Tremaya.
All right, thank you. Okay, Mr. Nowak, this is your motion. I've reviewed the motion. I know what we're here for, but if you want to lay out what your position is, that'd be great.
Just real briefly, Judge, and this motion seeks information related to what I'm going to generically call the hotline phone calls. Basically, the reports to the department regarding Kristen and her child. I appreciate the fact that the court's read the motion. I do believe that the code section 261.201 requires a court to take a look at these documents in camera and see if they fall within the exception of 261.201. Judge, that's my argument. Thank you so much.
Okay, and so I've reviewed your motion certainly, and I've also looked at the appropriate statute. So, all right, Mr. Trout, response.
Yes, Your Honor. As we spoke to Mr. Nowak about just shortly ago, the affidavit on the removal does state that it was original intake came in on May 2nd of 2024. My understanding that was possibly addressed at the original adversary hearing. That is a typo. On that one date was a typo. The actual intake came in on November 14th of 2024, which was a day before the investigation started. So there were no reports, secondary or third time reports that came in between May and November of when this case first started being investigated. So there were no reports in that period of time. As to whether this falls within the statute, as we all know, reporters are confidentiality is held in this very serious situation that the legislature has held those two in confidence. We don't believe that this falls within that. The report was made, some of it was due with neglect and danger of the child, drug use. We've had some mom not testing for us throughout the case. Some drug screens came back positive. So we do believe that it was a valid report. I don't see where, part of the statute for the judge to have the discretion to open up this confidential information is that it's essential to the administration of justice. We don't see where mom knowing who the reporter was is going to further the administration of justice in this case. I don't know that it's going to change anything as the report in our eyes came back as true. And that is why we ended up in a removal. It also has, the court has to find that it's not likely to endanger the life or safety of B2, the person who makes the report of the alleged abuse. This case, we've even had to hold a hearing with the copious amounts of emails and phone calls and texts that come through from mom to the department, to the workers. We've had instances of threats being made by mom. So in our eyes also, it does not fit that prong of the test. If mom knew who the reporter was, I don't think anybody can say that mom would not, for lack of a better word, harass at least that person, if not make threats toward them. So I don't believe it falls within either prong of these tests. But there's also an in-camera review for the court to look at these documents and make that decision. I do have a copy of that report that I can get to the court to review that. That is our argument, John.
All right. And Ms. Zavala, any position or anything to add as the child?
Mine would be the same as St. Francis, that the evidence all along in this case has supported what was alleged in the investigation. I see no exception to what's being sought. And I would have the same position as the department.
I think it comes down to the court's discretion after an in-camera review. I apologize for just blurting that out, Judge.
No problem. Blurt away. So I think that the statute, I think that 261, 201 does require me to review those before I make any ruling. So I would look for that documentation to be sent to me by Mr. Trout. I will take a look at it and then decide what is, really in the best interest of justice and whether or not any of those prongs, are met, or I think are met. Of course, Mr. Nowak, just depending if the case goes to trial and if that reporter had, very, I would think, relevant firsthand knowledge, had personally witnessed something, had videoed something, photographed something. I mean, whatever it might be, your client may end up knowing who that is ultimately at trial if they're subpoenaed to testify. So, if the intake, contained that kind of information, it may all be moot, I guess is what I'm saying in the end. But I also understand your client's request for discovery of that information in advance of trial.
Judge, Miss Campbell's in the waiting room now.
Oh, okay, let me bring her in. Okay, I've got Miss Campbell in now. Miss Campbell, if you can unmute or turn your video on or turn your video on, please, so I know that you are here and you can hear us. I'll send her a prompt to unmute.
Yes, ma'am.
All right, Miss Campbell, do you have your video?
I'm at JBS, so I can't turn my video on.
Okay, all right, very good. Okay, we are just about to conclude your motion hearing. This has been very short, Miss Campbell. Let me just give you some explanation. The statute that you are requesting some release of information, that statute requires me to review the documents. And I will do that as soon as those documents are submitted to me. So I will take a look at it, and then it's my job to determine whether or not they meet any of the kind of exceptions to the general rule that reporters regarding abuse or neglect of children that those are maintained in the strictest of confidence. I will tell you that, there's a number of things I would have to determine in order to release that information. One, is that, overall, that it's in the interest of justice to do so, but that, that would not generate or create any kind of potential harm or threat or, substantial, danger of any kind to the reporter. Now, that being said, I want you to understand that in your motion, you all alleged that there was an intake in May of, I believe this would have been 2024. That was a typographical error that was discussed at the adversary hearing. There were no intakes regarding you and or this child between May 2nd and or the actual intake, which came in, I believe they told me it was November 14th. So that May date was a typographical error. The original intake that led up to removal was November 14th of 2024. So that's going to be the intake that they're going to provide me the documents. That will be the intake that I review. You made some subsequent intakes regarding placement of the child. Those have all come after the fact. Those have all been investigated. And to my knowledge, I think everything's been closed out on those at this time. But the intake that I think is at issue here is the one that led up to, the department getting involved with you and the affidavit for the legal removal that was presented to me. So that will be the one that I will be looking at, and the only one that I will be looking at, because it is the only one that led up to removal.
Yes, ma'am.
All right. While we are all together, I want to take just a couple minutes. So I will review those, and then I will let everybody know what I intend to do about releasing or not releasing that information.
And Judge, can I make one more statement as far as that, just so I have it on the record?
Sure.
As far as the statute goes and what the court has to look at, the first part of section B on 261-201 states that a court may order. So even if my interpretation is, even if the court does find those things, it's still within the court's discretion on whether those are disclosed or not.
Correct.
If those make the problem, but I just wanted the argument on there also.
Correct. It's not a shall.
Yes, ma'am.
Language. So, okay. So while we're here, just very briefly, Ms. Zavala, I think you've had recent contact with the child. Is that correct?
I have. I got to video call with her just a few days ago. She looked great. She was excited about school, and is doing very well.
Okay. And did you address with the child is in a different placement now. Is that correct?
Yes.
And have you addressed with current placement some of the concerns that mom had with regards to her hair and some of just the other general concerns mom has had in the past?
I have not specifically, but I will tell you she looked great. Her hair looked amazing. I haven't seen any kind of need to bring up those issues, but I will state I didn't see a need to bring them up in the previous placements as well. I believe those were being addressed, but
Okay.
so yeah.
So let's see. Ms. Alford is the permanency specialist in the case. Ms. Alford, because mom is not having visits with the child, which was a court order because she's not drug screened for us. And I'll repeat that, Ms. Campbell. If you'll just go do your drug screens for us, we may be able to move forward here, but we're just kind of stuck. We are like really stuck in the mud.
Yes,
Deep mud until you go drug screen for me. So if you want to move things in the right direction, you gotta start drug testing for us. You gotta do services. That being said, Ms. Alford, since she's not getting visits, will you please request placement to take some, just take some photos of Tremaya, maybe some little short video snippets, something, so that we can go ahead and provide those to mom?
Yes, I actually did provide some to mom a couple of weeks ago after we had our family team meeting.
Okay, great. Somebody's already anticipated what I wanted to do, so that's
Yes, ma'am.
And Judge, I believe we're set for trial first week in December.
We are a jury
So
trial.
there is plenty of time for mom to drug screen and hopefully screen negative.
Yeah, I mean, there's time to spin things around and go.
And
to
it's my understanding under the current court order, we test clean, visits start back up.
That's correct.
Thank you, Judge.
Mom did drug screen after our family team meeting. We requested a hair and a UA. She refused the hair strand, and her UA did come back positive for methamphetamines.
Okay. Well, Ms. Campbell, all I can say is that I'm glad you UA'd. I mean, it's information that we've got to have for the safety and the protection of the child. But if you'll continue and if you'll go do those things, and you're going to have to give us a hair at some point in time. But I mean, I will just tell you, I mean, if I've said it once, I've said it 1,000 times, probably more. I can't send a child home into a home where the responsible parent, the caregiver, is actively using, a serious drug like methamphetamine. So, we want to help you. We'd love to help you get into rehab, or some program, or maybe you can try to get a handle on this. Because, the last thing we want to do is have the child end up, staying in foster care. And, I mean, I derive no enjoyment from terminating parents' rights. None whatsoever. The joy of my job is when we get to send children home to their parents. And everybody involved in this, everybody on this screen would agree with that statement. That's where the joy comes in, is when we can reunify families. So you've got time to turn this around, but only you can do that.
Yes, ma'am.
Okay, then I will see everybody back. We do have a little review hearing on September 30th. I'm not going to count this as a review, and Mr. Trout, I don't expect you to prepare a order. We'll get back together on September 30th and have a really full-blown review. But since we're here, I just kind of wanted to know how Tremaya's doing. So. All right, I will take a look at all this information. Council, I'll very likely just notify everybody by email if that's agreeable, instead of trying to get everybody back together.
That's perfect.
Okay. All right, then. I appreciate everybody's attendance today. Thank you very much, and you're free to go.
Thank you so much, Judge.
Thank you, Judge.
We'll be in touch.
And I'll drop these documents off for you, Your Honor.
Thank you very much.
Yes, ma'am. Judge, I believe we are back in and ready.
Okay. All right, are we gonna move forward as sort of what we've discussed? We'll proceed with testimony on Mr. Dugan Jr. and the unknown father today.
Yes, ma'am.
Okay, and then we'll recess, and then we'll resume Thursday at 9:45.
Yes.
To prove up mother's relinquishment.
Yes, ma'am.
Okay.
And Your Honor, I have a few witnesses here. I know they've moved some schedules around. Their testimony pertained to mom. I would I could go, if everything goes as planned, I could cut them loose today. We won't have to worry about that and get mom's relinquishment because they won't be a party to that. But I don't know how the court wants to proceed on that.
Well, let me just, I mean, is the plan that y'all are gonna attempt to get that executed this afternoon?
Yes, ma'am.
So you could let them know a little later this afternoon whether they're released from that
Yes, ma'am.
subpoena or not.
Okay.
Okay, so for those witnesses that you were anticipating on testifying today, that would be, go ahead and tell me, Mr. Trout.
Yes, it'd be Mr. Wieners, Miss Daly, Miss Perryman, and Miss Bryan. Some circumstances have changed since we got in this hearing today. I don't believe I'll be needing your testimony right now. You're still under subpoena. I'm gonna let you go ahead and go and get about your day. Everything works out today, I will reach out to you all this afternoon and let you know if I need you again. But as of right now, you would still be under subpoena until I release you from it. But I can let you go ahead and go and get on about your day today. And I appreciate you being here.
So they'll reach out and let y'all know about Thursday at 9:45. I don't think it'll be necessary, but there is that's just a slight possibility. So, but we will notify you ASAP so you can plan accordingly.
And again, thank y'all all for being here.
Appreciate your patience. All right, then. I will recall cause number 98735E in the interest of Zoe Parks. We initially called this case for the final on June 17th of 2025. We did take a significant amount of testimony that day. We recessed till today's date. And so we are still conducting this through Zoom. We are live streaming and Ms. Goodman is making our record. Okay, we'll go ahead and take announcements since we're here on a new day.
Daniel Trout for the department. We're present ready, Your Honor.
Mr. Hamker, on behalf of James and Krista Elrod, we're here and ready, Your Honor.
Your Honor, I'm Tate Eldridge. I represent the mother, Mandy Parks. We're both present, ready.
Jeff Hill, on behalf of the unknown father, ready.
Stacy Zavala on behalf of Zoe.
All right, thank you all very much. Also, just to clarify on the record, John Dugan Jr., an alleged father in the case, is not present. He was personally served back on October 24th of 2024. He never has requested an attorney in this case. So I'm sure we'll obviously have further testimony regarding him, but I just want that on the record when he was served.
And I just want to make sure, Your Honor, I just sent Mr. Hamker the exhibits since he wasn't involved in the last hearing when we called, just to make sure everybody else still has the exhibits from the June date.
I have no objection to any exhibits that you filed.
Okay.
Okay. Ms. Katie, if you wouldn't mind to locate those and resend those to me, I sure would appreciate it. Thank you. Okay then. Mr. Trout, I guess you can call your first witness.
Yes, Your Honor. I believe when we recessed last time, Ms. Parks was on the stand. I would ask to release Ms. Parks at this time and call Jalissa Bird, Your Honor.
Okay. All right, Ms. Bird, if you will, raise your right hand for me. You solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, very, very well. You may proceed.
Thank you, Your Honor. Ms. Bird, would you state your name for the record, please?
Jaleesa Bird,
And Ms. Bird, how are you employed?
St. Francis Ministries.
And are you familiar with the case involving the child Zoe Parks?
Yes, I am.
And how are you familiar with that case?
I'm the permanency specialist on the case.
You heard the announcement. We'll take some testimony as to the unknown father and to Mr. John Dugan Jr., correct?
Yes.
Okay. Have you had any contact with Mr. Dugan?
I have not.
Okay. Did the department, did St. Francis generate family plans of service for Mr. Dugan?
Yes, we did.
And were those family plans of service made in order of the court?
Yes, they were.
And were those filed with the court in June of 2025?
Yes.
And the plans were generated in April of 2025, is that correct?
That's correct.
Were you ever able to, were those plans made in order of the court?
Yes.
Were you ever able to meet with Mr. Dugan? Was he ever incarcerated? Were you ever able to speak with him?
I was not.
Okay. Do you see exhibit number 5?
Yes, I do.
And are these the family plans of service that you generated for Mr. Dugan and were filed with the court?
Yes.
And are family plans of service services made in order of the court in order to help parents try to reunify with the child?
Yes.
Okay. And that was done in this circumstance?
Yes, it was.
Did Mr. Dugan ever work any of these services?
No, he did not.
He was personally served, as the court announced a second ago. Did he ever make contact with you?
No.
Did he ever try to visit with the child?
No.
Did he ever reach out to try to ask for visits with the child?
No.
Your Honor, I'd ask to admit exhibit number 5 is the family plans of service that were ordered in this case as to Mr. Dugan.
Any objection?
No objection. Interveners have none.
Mr. Hill, I didn't hear you. You may have been talking at the same time with someone.
No objection.
Okay. All right, petitioner's exhibit 5 will be admitted.
Thank you, Your Honor. Ms. Bird, at this point, Mr. Dugan's an alleged father, correct?
Correct.
We never found him in order to do any paternity testing or to decide if he was the biological father, correct?
Correct.
Also, exhibit number 3, did the department run a certificate of paternity registry search?
Yes.
To see if any alleged fathers had registered with the paternity registry?
Yes.
Did anybody ever register with the paternity registry search?
Not to my knowledge.
Exhibit number 3, is that a certificate of paternity registry?
Yes, it is.
And does it state that no one is made and no notice of intent to claim paternity as to Zoe?
Yes.
And that was filed with the court in July of 2024, correct?
Yes, it was.
Your Honor, I'd ask to admit exhibit number 3 is the file marked copy of the certificate of paternity registry search that was testified to.
No objection, Your Honor.
No objection?
No objection.
All right, petitioner's exhibit 3 will be admitted.
Thank you, Your Honor. Ms. Bird, is the department here today asking that the paternity rights of any unknown father, unnamed father, and John Dugan Jr. also both be terminated based on failure to register with the paternity registry search?
Yes.
And in Mr. Dugan's, if the court deems necessary to adjudicate him, because he was personally served in this case, constructive abandonment?
Yes.
And do you believe that's in the best interest of Zoe?
I do.
And at this time, you believe best interest of Zoe is to stay with the Elrods?
Yes.
and for that placement to continue.
Yes.
I'll pass the witness, Your Honor. Oh, excuse me, Your Honor, real quick. Sorry, a couple more questions. Ms. Bird, how is Zoe doing?
Zoe's doing well. She's meeting all of her milestones. She's thriving, walking, starting to talk, just doing really well in her placement.
And she's bonded with the Elrods?
Yes, she is.
They're taking care of all her needs?
Yes, they are.
And as far as with Mr. Dugan or any unknown father, she has no bond and no connection with him or any other possible fathers?
That's correct.
Okay. And you, due to that, you believe it is in the best interest to terminate the rights of any unknown father and Mr. Dugan?
Yes, I do.
I'll pass the witness, Your Honor.
Okay, Mr. Eldridge.
I don't have any questions, Your Honor.
All right, and Mr. Hill?
No questions.
Excuse me, Mr. Hamker.
No questions, Your Honor.
Okay, Ms. Volley.
No questions.
All right, Mr. Trout, anything further of this witness?
Nothing further this witness at this time, Your Honor, until we take care of the other situations we were talking about earlier, till we reconvene.
Okay. Okay, then Mr. Eldridge, anything to present today?
No, Your Honor, I don't have anything to present today. As Daniel stated, I'm gonna go with and meet some of the CPS employees and get the relinquishment signed and witnessed and notarized, and try to have that back to you this afternoon or filed this afternoon. There's a couple other documents as well that Mr. Hammaker sent over, and I'll get those signed as well.
All right. Since we will be coming back Thursday with respect to your client, then we're not going to consider that you've arrested at this time. Okay, Mr. Hill?
No witnesses, Your Honor.
All right, Mr. Hill, do you rest?
Yes, ma'am.
Okay, Mr. Hamker?
Your Honor, I have no further witnesses at this time.
Do you rest at this time?
Yes, we do.
Okay. All right.
Hey,
Ms.
Your Honor.
Zavala, Ms. Zavala, you may wish to wait till Thursday. I'm not sure. Somebody was saying something.
So that was me, Your Honor. I'm sorry. I forgot about that part of it. I need to explain to my client what we're doing. We've made all these agreements and things, and she doesn't know anything about it. I need to explain to her.
Yeah, you want to talk to her in a breakout room real quick?
Sure, if you don't mind.
Yeah, no problem. All right, Tate, I'm going to move you to room 3. Ms. Parks, you're going to get a prompt to go to room 3.
Judge, that's all good. Mandy agreed to that. We're gonna meet at her place at 2 and get all these documents signed, and I will probably get them uploaded this afternoon before I go home.
And hey, Tate, as far as the relinquishment, when it's all completed, my workers will take it because they'll have somebody sign one part of it, and they'll send it to me, and I will get it filed.
Okay, you're right. You guys haven't even signed it yet.
Yeah.
And Tate, if you would send me those other ones that I sent to you, I'd appreciate it.
Yes, sir. I'll get them to you. Should get them to you this afternoon to the plan.
All right, good deal.
And Tate, you verify the address you're going to?
The address is
we're on YouTube, so you may not want to say it out there.
yeah, it's the one on Carolina.
Okay.
Is that the one you guys have? It's
Yes.
the same one.
Yeah, Jalissa said yes.
Okay. So make sure they're bringing a notary and 2 witnesses. I just need to bring me and
Correct.
the documents.
That's correct.
Okay, sounds good.
Judge, you're muted.
Sorry, Ms. Zavala, do you want to wait till Thursday then to present anything and or your recommendation?
I think that would make the most sense, Your Honor.
Okay. All right then, so I'll just withhold on making any ruling. Mr. Hill, I don't think your attendance will be required Thursday at 9:45 unless you just want to log in. If you do, that's fine. If not, we'll make sure that you're notified about the ruling.
Okay, yeah, I think Judge, there's probably no reason for me to be there.
Okay, very good. Okay, then, for those that will need to be, I'll see you back Thursday at 9:45, so we'll be in recess until that time.
Okay,
Thank you, Your Honor.
Thank you.
Ms. Parks, you know, I may or may not see you Thursday. Your attendance, if you sign the relinquishment, that's purely up to you. And Mr. Eldridge certainly will be there on your behalf, and if you choose not to be there, that's fine. So in the event that you are not present Thursday, I just want you to know I respect how difficult a decision this is, and I appreciate you putting your child's best interest ahead of yours and doing what you think is best for her. And so I wish you continued good luck, and hope this all, will work out really pretty well for everybody. So thank you very much. All right, then. I'll see everybody else Thursday at 9:45.
Thank you, Judge.
Ms. Goodman, thank you very much.
Thank you, Judge.
I appreciate your help today. And just so I'm clear about that will be September 11th.
Yes, ma'am.
It's Thursday, September 11th. I don't think I ever announced that actual date, so we'll be clear about that.
Yes, ma'am.
Okay. Thank you all so much. In the interest of Derek Ramirez Santos, this is the Department of Family and Protective Services versus Elida Wendy Ramirez Reyes and Agner Santos. We are here today on a request for court-ordered services, and Ms. Lucero was appointed to represent the mother in the case, Elida Reyes, and my understanding is that Ms. Reyes and Ms. Lucero have signed an agreement. They've agreed to work services and have signed an agreed order, so neither is present today. So we probably need to take some testimony with respect to Mr. Santos and what contact we've had and his role in this. So, Mr. Groff, if you want to, I know you may have some other witnesses in the waiting room. I don't know who you need to call first.
Well, I think we may be able to get by at this time with just Ms. Taylor, so I would start with her and see what we can do. If we need to call the others following her testimony, we can do that.
Okay, you may just leave them in the waiting room for now.
Yeah, that would be fine. I told them they might not get called right away.
Okay, very good.
Thank you.
Okay, Ms. Taylor, if you'll raise your right hand for me. You solemnly swear or affirm the testimony you'll give today will be the truth, the whole truth, and nothing but the truth.
I do.
Very good. All right, you may proceed.
Thank you, Your Honor. Good morning, Ms. Taylor. Who are you employed by?
I'm an investigator with the Texas Department of Family and Protective Services.
Okay, and for how long have you been employed by DFPS?
3 years.
Okay, and what is your training and experience?
I have training. I've been through both the Academy for Conservatorship and investigations. So I have training in both. And now I'm an investigator.
Okay. Are you familiar with the family of Derek Ramirez Santos, Wendy Ramirez Reyes, and Ackner Santos?
Yes, I am.
How so?
I was the investigator assigned to a report that we received.
Okay. And were the allegations in the affidavit true and correct to the best of your knowledge and belief?
Yes.
How old is Derek?
Derek is only, I believe he's only like 5 or 6 months.
Okay. When were you assigned to this case?
So I received my report on August 13th.
Okay. And what were the allegations that prompted the department involvement?
There was allegations of domestic violence between the father, Mr. Agner Santos, and then the mother, Miss Elida Ramirez Reyes.
Okay, Mr. Groff, let's stop for a minute. It looks like mother is logged in.
Okay.
I still don't have Ms. Lucero, but she's logged in. So Mr. Perales, I'm going to bring her in. And I'm going to try to just explain a few things to her real quickly.
Thank you.
All right, Mr. Prowse, if you want to go ahead and make sure she can unmute and we've got good contact and who is with her.
Ok, buenos días, señora Elida Reyes. Vamos a poner la función de interpretación. Tiene que escoger español cuando la juez prenda la función, ¿ok?
Ok.
Ok, gracias. Ahí va. Ready, Judge.
Who's with her,
¿Quién
Mr.
está ahí
Prowse?
con usted, por favor?
Yo y mi novia. Y una amiga. Y una amiga. Y mi niño.
It's me and my boyfriend and a female friend.
Okay. All right. Is Ms. Reyes, is it it's my understanding that you had agreed through your attorney to work services.
Tengo entendido que usted había concordado, o sea, que usted llegó a un acuerdo y dijo, le dijo a su abogado o su abogada de que estaba de acuerdo en cumplir con el plan de obligaciones.
Sí.
Yes.
Okay, your attorney is not present today and your attendance is not absolutely necessary, but you're welcome to remain if you want.
Su abogada no está presente en este momento. Ahora, usted no tiene que estar presente. No es necesario si usted no quiere estar conectada. Y si quiere, está bien.
Ah, ok. No.
I believe the boyfriend is Mr. Morales' client, Your Honor.
Why do you
Yeah,
think?
yeah, Your Honor. I was just gonna say before she left,
It's
I
not.
think she said her boyfriend was.
No puedo hacer así.
Judge, can we try to... Oh, never mind. Sorry.
Yeah, we'll probably gonna have to set up interpretation here in just a second. Would you just ask if the boyfriend is Mr. Santos?
Señor, ¿usted es el señor Santos?
Sí,
¿El que es parte de de este caso?
sí.
Sí. Yes. Part of the case.
Okay, Mr. Morales, would you like the opportunity to obviously visit with him privately?
Yes, please, Judge. Sorry.
Okay, Mr. Morales, if you would let know that his attorney wants to speak with him privately and maybe he can take the phone and go somewhere in a different room to speak privately with his attorney since Ms. Lucero's not here.
Señor Santos, su abogado quisiera hablar con usted en privado. ¿Será posible de que usted se vaya a otro cuarto con el teléfono para que hable en privado con su abogado? La señora Lucero, la abogada de su novia, no está conectada.
Está bien.
Sí.
All right, I'll go ahead and set you all in a breakout room. Now let's see if I'm correct. Mr. Morales, we can't use that interpretation in the breakout room, can we?
No, no, correct. I'm sorry.
So we'll wait to set that up till you all come back in. So if you'll let him know, they're gonna get a prompt to go to room 1.
Judge, I'm back. Mr. Perales was explaining him the interpretive function,
Okay,
and we are going to announce that we're in agreement as well to work services.
great, okay. Mr. Groff, do you want me to pull any of your people in and release them?
That would be great. I don't know if their names are there, but we had Ms. Escalante, Erica Escalante, and Flora Laura as potential witnesses if needed.
Okay, I have both of them. I'll bring them in.
Thank you,
Can we
Judge.
also let my supervisor in, Melody Zuniga?
Oh, sure.
Oh, and if Mr. Taylor is there, or excuse me, Mr. Miller is there, the attorney from Lubbock, we also would ask that he be admitted. He's observing today, Your Honor.
Oh, sure.
Thank you.
Sure. Okay, Ms. Loya and Ms. Escalante, my understanding is that the parties have reached an agreement in the matter, and so your testimony will not be necessary today.
I believe Ms. Loya speaks English, Your Honor, but Ms. Escalante would need Mr. Perales to interpret.
Okay. All right, Ms. Loya, can you unmute your device for me?
Yeah, I'm here.
Okay, Ms. Loya, your testimony will not be necessary this morning, so I wanted to let you know that you're free to go at this time.
Oh, okay, thank you.
Thank you very much. Okay, Mr. Perales, I've got you all back in. Mr. Perales, if you would just assist me to interpret, I'm trying to release a witness. I have a Spanish-speaking witness, Erica Escalante. I need her to unmute.
Señorita Erika Escalante, ¿pudiera prender su micrófono? Está en silencio. Ahora sí.
Ahora sí.
Gracias.
Escalante, this is Judge Baker.
Entonces, señorita Escalante, yo soy la juez Baker.
Mucho gusto.
Nice to meet you.
The parties have reached an agreement, and so your testimony will not be necessary this morning.
Las partes llegaron a un acuerdo, por lo tanto, no será necesario su testimonio esta mañana.
Okay.
You are free to go at this time, and we appreciate you logging in.
Puede desconectarse. Muchas gracias por conectarse esta mañana.
Está bien. Gracias.
Gracias.
Okay, thank you, Mr. Perales. Okay, at this time then, are we ready, you think, to try to set up interpretation?
Yes, Your Honor. Ok,
Right.
ya, el señor ya lo va a prender. Ahí va.
Okay, I have started it. If everybody will select their language, please.
Sí, sí, lo escucho.
Terrific, thank you. All right, then, Mr. Groff, I'll interrupt where you were just briefly. So in the interim, Mr. Santos, we realized is present, and he's had an opportunity to speak with his attorney, Mr. Morales. My understanding, Mr. Morales, is that he is in agreement to work services. Is that correct?
Yes, Judge, that's correct.
Okay, then, Mr. Groff, anything else you really need to present?
I don't believe so. I just would like to thank the parents for their cooperation and hope that they can get on board with services so we don't have to be involved in their lives any longer than we have to be.
Okay, so do either Ms. Reyes or Mr. Santos have any questions for the court?
Sí. Que lo que pasó con la señora no es nada nuestra, no sé por qué es lo que se metió en nuestras vidas. Con la persona que puso la demanda.
Well, the case was brought by the Department of Family and Protective Services, not a person.
Porque ahorita escuché hablando a la señora, por eso le decía eso.
Okay, maybe somebody in the background.
Una señora, la señora la conozco, la que iba a dar un testimonio.
Oh, okay. I don't know what her testimony was going to be, and it doesn't matter at this point in time, since the two of you, who are the parents, have agreed to work services.
Sí, nosotros dijimos que vamos a cumplir con eso, pero que si ustedes se hacían cargo, porque no tengo dinero, porque hace poco tiempo llevaron a Elida Reyes al hospital con engaños y ahorita tengo un bill que pagar y ahorita no tengo dinero cómo pagarlo. Y eso no está bien, cómo la llevaron con puros engaños, eso no estuvo bien.
Okay, well, Mr. Santos, I don't know about that, but all the services that we are going to ask for you both to do, I think will be covered and paid for by the department.
And Your Honor, I would just let him know also that he'll be getting a different caseworker that will work with him.
So as we move forward through the case, there'll be some other people contacting you. And most importantly, I want you to know who Ms. Zavala is. Ms. Zavala, I'm going to ask you to say something because they won't, obviously on the phone, they're not going to see you unless you speak.
Hi, I'm Stacy, and I'm your child's attorney.
Okay.
Ms. Zavala will be reaching out, or her office may be reaching out to you periodically to see the child.
Okay, perfecto.
And so it's very important that you all return her phone calls or her assistant, Kelly.
Sí, pero tengo una duda.
Okay.
Que si pueden llamarme antes de lunes a viernes de las 12 de mediodía para atrás, porque yo trabajo y más adelante no puedo responder el teléfono.
Okay, I'm sure Ms. Zavala will make a note of that. And then your caseworker that will be assigned to you will be meeting with you to talk about all of those kinds of issues. When you work, when you can work services, all of those scheduling issues.
Okay, perfecto.
Okay. Mr. Groff, do we know who the assigned worker will be?
I don't, but will defer to Ms. Taylor. She might know.
There is not one yet, but we'll make the referral today and it will be assigned within the next like 24 to 48 hours.
Do you want to let them know? You text them or call them and just let them know when you have that person?
Yes, yes. I will let them know who it will be and who will be reaching out.
Great, thank you.
All right. I appreciate everybody's showing up today. I wish the parents good luck. I'm going to go ahead and enter the order to participate in the requested services. And I will see everybody back for our compliance hearing on December 4th of 2025 on a 9 o'clock docket. For the parents' benefit, your attorneys will let you know exactly what time you need to show up for court. And it will be here on Zoom, just like today. My docket starts at 9, but I may have other cases before yours. So they'll let you know exactly what time you need to log in. All right, then I'll see you back in December. Good luck, and thank you again for your cooperation.
Thank you all.